Continuing on in Unit 3, Objective 50 says discuss various methods of measuring quality improvement. Total quality management is a part of quality improvement, and the overall goal of total quality management is to improve the system. Continuous quality improvement identifies areas of concerns and continuously analyzes them. Some major indicators that follow under continuous quality improvement include number of falls, medication errors, and infection rates. Six Sigma is a method for measuring quality improvement. It uses the DMAIC nomenclature to look at quality improvement. Basically, it is to define opportunities, measure the performance, analyze the opportunity, improve the performance, and control the performance. Lean Six Sigma basically is using a reduction of supplies at the patient's bedside, and it's just a leaner version of that Six Sigma. Basically, these quality improvement measures is to reduce costs and improve the quality of care to the patient. Objective 51 says define and describe risk management. Risk management is related to both quality improvement and quality management. It is a problem-focused approach. Its primary purpose is to identify, analyze, and evaluate risks, then develop a plan for reducing the frequency and severity of accidents and injuries. It is a continuous daily program of detection, education, and intervention in all departments of an organization. Each individual nurse is a risk manager and has the responsibility to identify and report unusual occurrences and potential risks. Risk management looks at national patient safety goals for hospitals, long-term care facilities, and ambulatory care in order to help reduce the risk potential of these goals. A risk management program identifies potential risks for accident, injury, and financial loss. It uses a review of current organization-wide monitoring systems. It analyzes incidences and plans risk intervention strategies. It monitors laws and codes related to patient safety and care, and it evaluates the results of a risk management program. Using a risk management program will eliminate and reduce the risk to clients in a healthcare setting, thus reducing law malpractice and lawsuits. It will review client care procedures and programs to make them more efficient. It reviews other departments to determine potential liability and recommend prevention or corrective action. It identifies the needs for education to reduce potential risks and provides reports to administration and to the board of directors of the facility. Going along with quality improvement and risk management is utilization review. Objective 52 says evaluate how utilization review impacts patient care. Utilization review consists of examining trends and proposing advantageous disposition of resources. Specifically, utilization review looks at the length of stay versus reimbursement from DRGs. And DRGs is diagnostic related groups. It's basically how the large hospitals get reimbursement for each medical illness of the patient. So if the patient's hospitalized with pneumonia, they get X amount of dollars. If the patient's hospitalized with pneumonia but also has hypothyroidism on top of it and also has type 2 diabetes, they would get so much more X dollars. Utilization review basically looks at that and uses critical pathways to make sure the patient stays on track so they can be dismissed in a timely manner, thus promoting good use of hospital staff and reimbursement so that the hospitals can break even. Utilization review also looks at allocation of resources. It looks at the nurse-to-patient ratios on various units, and it will help adjust resources as needed, thus leading to better patient outcomes using the least amount of resources. In some of the small hospitals around this area, instead of having patients on 2 floors, the utilization reviewers may say, why don't we move all the patients to 1 floor, close the other floor, and they use all of our supplies and stuff on one floor instead of having it on 2 floors. Objective 53 says define law. Law is the sum total of the rules and regulations by which a society is governed. Nurses must know applicable state law and use the Nurse State Practice Act for guidance and appropriate action. As a nurse practicing in the state, you must know and have read your Nurse State Practice Act, which is the minimum competencies and what you can do as a registered nurse in this state. Objective 54 says differentiate between criminal, civil, and tort law. Criminal law is conduct that is harmful to another individual or society as a whole and may be punishable by fines or imprisonment. Civil law is the rights and duties of private persons or citizens, and is most often enforced through awarding damages and compensation. Tort is a civil wrong committed against a person or a person's property. It can either be unintentional or intentional, and compensation may be awarded for those wrongfully injured by these actions. So these are basically just pure definitions of what is criminal law, what is civil law, and what is tort law. You can also have unintentional torts, which would include negligence and malpractice, and intentional torts, which would include assault, battery, and false imprisonment. Objective 55 says discuss laws that impact nursing practice. Informed consent is one of the things that does impact nursing practice. Expressed consent is actually where the patient will physically sign their name on a consent form. Implied consent is often things like first aid, where the patient is physically or mentally capable of consenting to something because of the situation they're in, they aren't able to actually give that consent or not, such as going to the ER. If you go to the ER and you are seen without signing a consent, you are basically giving implied consent because you sought treatment. The Controlled Substance Act impacts nursing practice. Nurses cannot call prescriptions for Schedule Type 3 or C3 or C4 medications for physicians, and the physician must actually give the patient an actual script to hand in to the pharmacist. Good Samaritan laws protect the nurses that give first aid treatment to a victim, as long as you give first aid within your scope of practice because you have good intentions and not malicious ones. The State Nurse Practice Act, it's legally what you can and cannot do as a nurse. It is a law that is developed by the state government and enforced by that state's Board of Nursing. You must know the individual State Nurse Practice Act in which you practice in because it's legally what you can do as a nurse in that state. Objective 56, discuss malpractice in healthcare. Malpractice is conduct deviating from the standards of practice dictated by the profession. And again, those standards of practice are often dictated by professional organizations and policies and procedures. In order to have malpractice, you have to have duty, breach of duty, foreseeability, causation, injury, and damages. And if you look at Table 5.1 on page 71, all of the elements of malpractice are discussed in that table. Negligence is a failure to deliver the standard of care. It is failure to exercise the care that a reasonably prudent person would exercise in a like circumstance. Basically, harm was caused to the patient by carelessness, not by intentional harm. Malpractice is a type of negligence. It occurs when a licensed professional fails to provide services as per the standards set by the governing body or the standard of care, and subsequently there was harm done to the patient. Objective 57, discuss ways to protect the nurse against malpractice. First is to document accurately and contemporaneously, meaning you document at the same time as things happen. Maintain patient safety and develop a good rapport with your patient. Minimize the risk for medication errors by using your triple check or by using the 6 rights of medication administration. Use effective communication and again developing that good rapport and trust bond with your patient. Have professional liability insurance for situations where potential malpractice lawsuits could be brought against you. Be accountable for your actions and take accountability if you make a mistake. And using continuing education to further your knowledge in the area of nursing in which you are practicing. Objective 58 says discuss situations in which the nurse is a mandatory reporter. Every nurse in the state of Iowa must take the mandatory reporting class every 5 years. For me, it's just a good rule of thumb to do it every 3 years when the license needs to be renewed. Mandatory reporting is a legal requirement to report an act, event, or situation that is designated by state or local law as a reportable event. Reportable events include neglect, physical abuse, sexual abuse, or emotional abuse. Abuse or suspected abuse of vulnerable individuals, including children, elderly adults, developmentally delayed or mentally incompetent individuals, and reporting certain illnesses and certain types of injuries such as STDs and HIV. Describe state and federal guidelines related to mandatory reporting of client conditions. If you go to the following website, it'll take you to different types of must reports that vary state to state. Not reporting any incidences related to mandatory reporting is a violation of the Nurse State Practice Act, which can affect your licensure, and you could be charged with a misdemeanor and potentially be liable for a civil suit if brought forth by the patient because you didn't report a situation that was mandated. Objective 60 says evaluate the legislation of the Whistleblowing Act of 1989. If you've heard of LRON, you've heard of whistleblowing. Whistleblowing occurs when you report gross misconduct as part of employers of federal authorities. Basically what whistleblowing is gross misconduct that you report. The Whistleblowing Act of 1989 protects you from or individuals who report gross misconduct as part of their employers to the federal authorities. However, it's not without incidents. Nurses, it's basically when you want to report a situation at work that is truly a problem but you are afraid. Nurses should view whistleblowing as an extreme last-ditch strategy to protect public welfare and should also take a step back before leaping into whistleblowing. Have you gone through the appropriate chain of command before you go into whistleblowing? If you go to the YouTube video link that's located on your slides here, it'll take you to a short video about whistleblowing. If you are involved in a whistleblowing case, use the following information. If you identify an illegal or unethical practice, reserve judgment until you have adequate documentation to establish the wrongdoing. Do not expect those that are engaged in unethical or illegal conduct to welcome your questions or concerns about this practice. Seek the counsel of someone you trust outside of the situation to provide you with an objective perspective. Consult your state, nurses association, or legal counsel if possible before taking action to determine how best to document your concerns. Remember, you are not protected in a whistleblower situation from retaliation from your employer until you blow the whistle. Blowing the whistle means you report your concern to a national or state agency responsible for regulation of the organization which you work for. In the case of criminal activity, a law enforcement agency may be reported as well. Private groups such as the Joint Commission or the National Committee of Quality Assurance do not confer protection. You must report to a state or national regulator. Although it is not required by every regulatory agency, it is a good rule of thumb to put your complaint in writing. I would suggest that. Document all interactions related to whistleblowing situations and keep copies in your personal file. Keep documentation and interactions objective. Remain calm and do not lose your temper, even if those who learn of your actions attempt to provoke you. And remember that blowing the whistle is a very serious matter. Do not blow it frivolously. Make sure you have all your facts straight before taking action, because it can lead to civil and criminal charges brought up against you if you don't have all your documentation and you use false information to blow the whistle. It's a very, very serious thing and should only be done as a last-ditch effort after you've reported it in writing to using proper chain of command. If you have any questions about Unit 3, please let me know.